morning, Your Honors. May it please the Court. Kathleen Celio on behalf of the Commonwealth. I ask this Court to reverse the motion judge's allowance of the defendant's motion to suppress. Simply, when the officers entered the juvenile's school and received ID photos from the school, they did not need a warrant that was in a photo that was in the custody and control of the school at that time.
What makes you say that these are identification photos? Is that a generic, that is, these are photos that identify the juvenile, or is there something to suggest that there is something or some place that sets these aside as for identification of students solely, as apart from some other repository of photographs, annuals, other sources of photographs?
Well, it was in, we entered into the suppression hearing exhibit number 1. It's in the defendant's record appendix, page 1. Right. And it's 7 photos that state the Monument High School and the student. We do not have actually the juvenile's ID photo.
I understand.
Yeah, so
you know where they came from, other than from the security officer at the school? Where did the security officer obtain these? There
was no evidence of that. It was just from the school, based on all we have is Detective Ford's testimony that he contacted the officer at the school and that he gave them these, actually gave the juvenile's photo to him. Then he realized that he couldn't line it up with any other photo that was within the system, so he went back and asked for other individuals that resembled the juvenile.
Okay.
And I think that this court's opinion in Bucella is instructive of the analysis of this. I mean, first, as I say, the defendant has no expectation of privacy in this photo. One, it is not a school record within the meaning of the mass regulations, and looking at how this court analyzed it under Bucella.
But why isn't it a school record?
Yeah, why?
I mean, it's a photo that, even though redacted, is identifying a student by name and other identifiers, right?
It may be a record of the school, but what I'm saying is it is not under the definition of student record.
And why do you say that?
Because I think of what this court, in analyzing what a student record is under Bucella, it said you can't just look at it in terms of the definition, because if you've read the definitions of both student record and temporary record, it is circular and ambiguous, and that's what this court said in Bucella, which it is. So you look at the rest of the regulatory scheme and in the context of what makes sense. And if you look at the rest of the regulatory scheme, when they're talking about student record, they use the word information, data, that a third party can come in and interpret the student record for the parent or the juvenile. They lay out, that it's standardized tests, results, class rank, extracurriculars, evaluations, and a photo does not fall under that type of data and information.
Well, doesn't that depend? I mean, that's why I was asking the question. So you refer to this as student identification. So if it's student identification, that is, a photograph obtained in order to identify students, is that what you're suggesting?
And have the students be identifiable.
Right. So it's not like a candid, it's not a yearbook.
Well, there's no evidence that they couldn't have used these photos for the yearbook either. I mean, there's no evidence of that.
So if we say it's a student identification and it's used for purposes of identification, then is under the rubric of Bucella, I guess it's called, was it mandatory? I mean, would that be important?
I mean, there was no evidence of what circumstances led to this juvenile's photo
maybe
being
we need
on.
that evidence. So in the meantime, since we don't, but what would be important for our consideration if we were trying to figure out, is it part of the record? Is it important that it's mandatory or not?
No, not part of the record, because in Bucella, like they said, homework was obviously mandatory, but they still said that wasn't a student record. The mandatoriness didn't go to whether or not something was a student record or not. The mandatoriness, or whether you have to give something over on some level to a government agency goes to what I call the second part of its analysis, saying that it's not a student record, but whether we look at someone would maybe have an expectation that once you give over, or you have to give over something to a government agency, that it would be used for its intended purpose.
So why is there no expectation of privacy when you, let's say, are required to take a photograph by the school? You have to attend school. Then you have to have your photograph taken so they know who you are, make sure you're not somebody else. You have a right to be on campus, say, right? That would be the purpose. Then why do you say there's no expectation of privacy in the limited use of that photograph for that purpose?
Well, the purpose is to identify the student and have the student be identifiable, and that's exactly what happened here, was to identify this student.
Well, that's for purposes of a crime, not for purposes of whether they can be in school.
But that, I don't think that changes the difference of expectation of privacy. If you know that...
Go ahead.
Do you want me to proceed? Okay. I mean, if you know that your photo is going to be used in many ways to identify yourself or have yourself be identifiable, that it doesn't matter if it's within the school context or outside of the school context, because it's, you know that this is this ID is used to identify yourself. And so I don't think it changes on whether or not it's within the school, or residually whether or not the school then gives it to an officer to have a victim identify them of a crime.
But why, I mean, in a way, why isn't it just like the handwriting in Bucella, in the sense that, put aside whether it is or isn't part of a record, let's just assume it's not, doesn't qualify as part of the student record under the department's regulation or federal law. It's, let's say, it's required to be taken, the photograph is required to be taken, the school requires it, it is kept by the school, it is used for student identification purposes within the school, and the student and his parents do not expect or anticipate, just like with homework, that it is going to be used for purposes other than educational purposes within the school. So,
but I don't think that that's what Bucella says, that it's within the educational purposes. What they said is that it's homework. You expect that it's only going to be turned in and that a teacher grades it and then gives it back. And so then it wouldn't be used to compare, right, what you write on the wall.
it's not going to be given to somebody else to compare.
But it wasn't that. It was that you're using the student's work, and not the purpose that you think the student's work is, which is to
Well, you're using
analyze.
the photograph to create a photo spread for somebody to be identifying a crime that didn't happen on the school property.
But no, I mean, respectfully, I think that you're looking at its intended purpose, which is to identify, just to have the student be identifiable, and that is of the photo. I mean, I think that in some ways this parallels like an individual who gets an ID or an RMV photo at the RMV, because in some ways, like, you have to give over your photo in order to get a driver's license.
But you don't have to get a driver's license, do you?
No, but you don't, and you don't have to get a mass ID. But I think, I mean, even turning back to the issue of whether or not he had to go to school, there was no evidence in the record that he was what age he was. But if you look at the docket, he was 15 at the time that, if you take that the picture was taken in 2006, 2007, he was 15 years old. Under the statutes, he actually, if you look at 76, Chapter 76, Section 1, there are provisions for someone who is over 14 not to have to go to school. Practically, I understand practically, like, that person may be going to school at the age of 15. But it's the same way, I think, with an RMV photo or a mass ID. You don't have to have an ID. You don't have to have a license. But in practicality, like...
He does have to have an ID if he's attending the school.
But that's going back to the fact that it's not absolutely mandatory that he goes to school at that time under the stat. But it's the same way. But you don't have to, if you want to go to school, then you have to get the ID. The same thing with the driver's license or
Not
an
absolutely
ID.
mandatory. He'd be subject to truancy laws if he wasn't there.
No, if you
Or if he
look
goes
at
through some special procedure to get out from under, that cannot be what governs this case.
no, but what I'm saying is that I think that it parallels the idea of someone going to the RMV. To get a driver's license, you have to give over a photo. And that you know that photo could be used for other purposes. It's to identify you, and that's the same way of the juvenile in this school.
Can they keep those photos of all the kids that they took and then use them at subsequent lineups just to fill them in? without telling anybody? Do you think that's an expectation that students have and their parents have when they have these photos taken?
To those, I mean, quite frankly, to those photos, this juvenile has no standing to contest.
I just want to know what the expectation of privacy is with respect to a student. If you can take these student IDs and then use them as fillers for certain age groups, and then, I mean, gee, they might get picked actually because they look like someone, but but is that okay?
But I mean, I guess it goes to I mean, this just goes back to what I was saying before, the idea of the purpose is to identify or have the person be identifiable, and in that way, even
for the purposes of whether they have committed a crime.
But I don't think that if we look at it's just the intended purpose is, like I said, the identity and the identifiable. How that then is, that goes to the expectation of privacy, but how then that gets used ultimately doesn't actually go into whether or not you have an expectation of privacy. And I think that can be seen by what this court said in the jail call, is that you, like, in that way, they say, no, you don't have an expectation of privacy because they've told you that they could be recorded and everything like that. And they said, you know what? The fact that they give it over to law enforcement, it doesn't matter because you already didn't have an expectation of privacy. And I think here, if you don't have an expectation of privacy that you can be identified or identifiable, then you don't have a claim of how then that photo is used.
Can we go back to the point you have made several times about the purpose of the photographs is to have the student be identifiable for purposes of school.
But that's not
to determine whether or not the student is properly on the school grounds and within the school facility.
But that's not true, because I think that you could probably, if there was a crime committed at school that was taken care of internally by by the faculty.
In the context of the school.
But it doesn't change, because if you look at Buchella, it's just the intended use. They didn't say that it was just the intended use, and that intended use has to be for educational purposes. Because if you look at what it said within the
I'm just wondering, I guess this is just amusing, but I'm wondering if I agree with you that the purpose of the photographs is to make the students identifiable within the school context, then if some activity occurs away from the school, as in this case, whether there might well be an expectation of privacy.
But I mean, this goes back to, I don't think that it's only within the context of the school, like limiting it to only that. It's just the basic that this identifies you, that a photo identifies you, and obviously you have no expectation of privacy in in their face and walking around in the public and such like that.
Am I correct from the record? I mean, the record here is very slim, but can we infer that the purpose of the ID is to be shown to somebody? I mean, when they walk into a school, I assume they have to show their ID to some security person. We don't know that.
Right.
But that seems to be its logical purpose. I mean, the whole idea of an ID is to show it to somebody to identify themselves. So its purpose, in contrast to the homework, is to be shown to other people to verify that you are indeed a student. I mean, does the record support that? I mean,
I'm sorry, just rephrase that. I didn't.
I guess I mean, it seems that in general, the purpose of an ID, especially in an urban school, is to, as you walk in the school, you have to show your ID to show that you're a student. So it seems to me that this is quite different from the homework in Bucella, which its purpose is not to be shown to third parties. The very purpose of an ID is to show it to persons, to say, I am indeed a student. And the purpose of homework is not to show it to anybody other than your teacher.
That is correct. That is correct. And
or to show it at the movie theater to get a discount, or at the
riding on the subway.
Or riding on a subway. Right,
or
right.
any of the other things, benefits one gets from being a student.
Right, right. And I'm, like I said, there was nothing the record was slim is actually a nice way to put it. But I mean, I think that you can infer that, and it is shown, and it's for that person to be identified. And I think that if that's that purpose, then you have no expectation of privacy in your photo, and that the school then retains.
Okay, let's assume for the moment that you don't prevail on the rehabilitation of privacy issue. Do you still claim it was reasonable for the police to use it here? Because in Bucella, it was found to be reasonable.
It was. This is a little bit different than in Bucella because that was an internal investigation that was handed over, and this is the police using it. But I think that the police it had probable cause at that point to think that this individual had just at knife point had stolen iPod, and I think that going in, knowing they had probable cause and knowing that they couldn't use any other photo in order for this person to be confirmed or denied to be the individual that did that was absolutely reasonable.
They couldn't get a warrant?
No, I don't think that the warrant was necessary in this circumstance. It was within the school. They asked for it from the school. The school could decide whether or not they wanted to give it over, and they did. Thank you very much.
We'll have to leave it there. Thank you.
May it please the Court. Good morning, Your Honors. I'm Peter Onick for the juvenile. Your Honors, I would like to start by challenging Ms. Celio's assertion that there is no evidence of the source of these photos. There is, in the record, such evidence. Our brief on page 5 sets out a quote from Sergeant Detective Ford's testimony, in which he describes how he contacted Officer Kelly, the school resource officer, to ask him to get more of the photos, the 6 or 7 filler photos. And the quote is as follows. Sergeant Detective Ford says, basically I said to Kelly, quote, I'm not your administrator who's in charge of the database. Just ask him to please pick some more for us. So there's a database, and there's an administrator who administers the database.
I take it there is no evidence one way or the other on whether this is mandatory. You just say it, well, you can infer it probably is.
I think it's very fair to say, Your Honor.
Because I have a faculty ID, and I used to have it without a photo, and one day I went in and said, will you put a photo on my ID? And they put a photo on my ID. So I don't know.
The fact that we have 8 of these photos, and these photo cards with the high school, and the date of birth, and
they're identical, aren't they? I mean,
they're identical. They are little cards. You can see them. They're
Background.
And can we also infer that the ID's purpose is to be shown to others to verify that they indeed are students?
To others, but to what others? That is the question.
To persons arguably in the school to verify that
Certainly
you were
in the
indeed a
school.
student.
Yes, certainly in the school. And I agree that.
And possibly even to security personnel at the front door of a school.
Yes, I think that's fair to say.
do they carry this? Is there evidence that the student carries this? Or I guess I was inferring, but maybe not correctly, that these were just held by the school, but each of the students had one on him or her?
That is not clear on the record, Your Honor. There may be duplicates. The database administered by the administrator may have copies for their purposes, and the student may carry one.
Does
I
it
don't
make
know.
a difference? Let's assume that yes, the school has it, but it's also something the way that I have an ID and I carry it around and I can show it to whomever. Does that make a difference to you? I do show it for movie theater discounts, and I show it for whatever.
I'm not sure it makes a difference. If that is to say, if the student carries the ID, he decides to whom to show the ID. We're talking here about a massive intrusion on the student's privacy when the police go and procure the picture and then use it for their purposes.
Well, but it does suggest that it wouldn't exactly be reasonable I mean, insofar as the reasonable expectation is that it's going to be used for school purposes, it certainly broadens that, doesn't it?
We don't know for what purpose this ID was, what specific purposes. There is an additional clue I can tell you, Your Honors. If you look at the Exhibit 1, which is on Supplemental Record Appendix, page 1, you'll see a vertical oblong box at the very bottom of each card. It's blackened in. It's blackened in on the page that you have, but if you look at the originals in the juvenile court file, you'll see that those are barcodes. Those are barcodes. Each of those on each of the cards is a unique striped barcode. And one might well ask, well, what are the barcodes for? What is it that one might wish to have access to, or what is being tallied up by use of this barcode? And I suspect that the barcode is used to swipe. That's what barcodes do. You swipe, and then something is getting tallied up or
It would suggest that these are IDs that one carries and one shows, either you sweeping it barcode through a security point or for
Yes.
other reasons.
Yes, it does. And I suspect that these are for entry into the school, to pass security, perhaps to take books out of the library in the school, perhaps to procure lunch in the school cafeteria, which is keeping a tally of the transactions and that sort of thing. In other words, there are various transactions within the school for which this card is useful.
Now, here the school voluntarily gave these photos to the police.
Yes.
So why is it a search? I mean, I know what Buscella says, but I've never heard, apart from Buscella, of any time in which somebody gives information voluntarily to the police that it is viewed as a search, which must be supported by probable cause. Usually consent is sufficient.
The school gave because the police searched. The police came and asked.
That's conclusory. The police gave. I mean, if you went to the Registry of Motor Vehicles and asked for it, and the registry gave, is that a search there? That requires, I mean, we generally don't refer to it as a search when somebody voluntarily hands over information in their possession.
I think search is the overarching term. It's an unusual circumstance that the police went trying to find information. They found a ready donor of the information in the school. The school broke the CMR regulations.
Well, that's,
The
I guess, the other
regulations-
issue. So
The regulations plainly say
does it
that
depend then?
any dispersal of this information must be...
So then if it relies upon, then you're saying we should suppress because there was a violation of the CMR. That's your basis for saying we should suppress.
No, Your Honor, no. There's
Well,
a
you just-
violation of
well, then-
Article 14 in the Fourth Amendment.
Okay, but that requires it to be a search.
Right.
And that goes back to the issue of why is it a search when somebody voluntarily hands over information in their possession?
It was not the school's right to hand that over. Under the CMR, it was not the school's right
But
to
doesn't
hand it
that go
over.
then to whether or not the CMR was violated, which depends upon whether it's a student record or not?
The CMR was violated, but that is not the touchstone
And
of...
it's
of our-
violated because this is a student record.
Yes, absolutely.
Because then this cannot be shown without the approval of the parent? The person cannot be required to show an ID unless the parent expressly says it's okay for the kid to show an ID?
Parents, under the CMRs, parents have control over the dissemination outside of the school
Okay,
community.
so you're saying that right now, if any school were to say, we require you to show your ID before you enter, that is illegal under the CMR because they require parental approval for that to be done?
No, Your Honor, within the school community, the card is meant to be shown to have access to different parts of the school, to enter the school. We're talking here about outside of the school. When the
Okay,
police
and
use
if the school, for reasons of security, were to bring in an off-duty police officer to serve as a security officer to check because of problems at a school, that cannot be done without going to the parent and getting parental approval?
Are you saying if an off-duty police officer works in the school and approaches students and asks them to show their pictures?
He's basically brought in on detail to say, we've got serious problems with regard to outsiders coming into the school to sell drugs or to do whatever else, and we want to make sure that the only kids who enter our school are students who have IDs. So we're going to bring in somebody to check IDs before they come in. You're saying that can't be done unless the parents give the approval of the student to be able to show the ID.
I do not say that, Your Honor. I think, of course, that could be done.
Okay, so if that can be done, then it's okay to show these documents to persons who are police or to persons who are security?
Only for school-related purposes. This was not a school-related purpose,
Okay,
Your Honor.
now, you say that. Is it not a school-related purpose to determine whether or not a student in your school is by knife point robbing other kids?
It is not a school-related purpose to inquire in this way about an incident that happened a substantial bus ride away from
But he's
the
your
school.
student. I mean, is it not, it's not appropriate for a school to say, if I have a student who is robbing other kids, I've got a problem. And I need to know whether or not I've got a student in my school who by knife point is terrorizing and robbing other children. Does that not pose a problem, arguably even with the bullying issue?
Your Honor, if I'm the principal of a school and police come to me and they say, look, we have some inkling that one of your students may have...
Inkling we found is identification, right?
All right. Well, we have a student whose name matches a student in your school, that of the student in your school. We have reason to think he may have been involved in an incident on Blue Hill Avenue, some miles from here, several weeks ago or a week ago. There's no emergency, incidentally. We're talking days and weeks past while this was evolving.
I mean, but
Can we please have his information that's in your file? The answer is no.
Do we have a statewide concern about bullying?
Of course we do, Your
And,
Honor.
and is this not the most aggravated form of bullying, is to be robbing a kid at knife point?
Your Honor, there is a warrant requirement. Get a warrant.
Because it's a search?
Would the distinction be that this isn't on a campus and that
It is
the
not on
police
campus.
officers are asking the school officials to act as an arm of the police in performing the police function, which is a crime not occurring on a school campus,
Not occurring
but
anywhere near the
outside of
school. It's a bus ride away.
Right.
It's a bus ride
So
away.
then is the question whether the school officials were acting as an arm of the police when they were
Yes.
asked to hand over the photograph?
Yes, and the case law is clear. The case law is clear.
When you say it was a bus right away, this didn't happen on a school bus, did it?
Not on a school bus, no. An
They got off.
MBTA bus, three students, allegedly including the juvenile, plus the complaining.
If it happened on the bus, would it make a difference?
On the bus but away from the school?
Yes.
No, it would not make a difference.
They would still need a warrant?
It's an MBTA bus, Your Honor.
Oh,
It's not a school bus.
it's not a...
If it's a school bus,
If
maybe
it's a
the-
school bus.
No, but that's an interesting distinction. But no, it's an MBTA bus.
All right.
And it's going to Blue Hill Avenue, some substantial distance, inferably, because they're taking a bus to get there. And then they get off the bus and walk down a street, and that's where it happens. Now, Article 14 and the Fourth Amendment prohibit the police from just going back to the school, by the way, like a week later, and saying, by the way, we have reason to think that one of your students is involved. Could we please have his record,
So the only-
His photo.
his photo?
So the issue here is,
Inferably, why not the rest of his record, Your Honor? Why not his whole file?
Because, well, one
Why
can argue,
not?
but the difference is that a photo is intended to be shown to others, while a transcript is not.
But
And
the
plus, the
student-
transcript is protected differently than, I mean, we're getting down to the other issue. I guess in Buscella, we didn't say you must get a warrant. We said it was reasonable.
Yes, because the school was the actor. It wasn't the police, Your Honor.
But
That's
it was,
the big
but it was
distinction.
ultimately a criminal investigation.
in school.
But when the school is the actor, the standard is relaxed.
And
When it's the police acting or the school acting at the behest of the police, it's a probable cause standard. A warrant must be procured. That is the standard. That is the standard.
And
Your Honor,
then
could-
the focus is on whether there was a reasonable expectation of privacy.
Yes, of course.
And that's why you're focusing on that question.
We assert, of course, yes, there is. It's part of his, our position, of course, it's part of his record. He has a reasonable expectation of privacy. We know that because the CMR, for instance, is shot through with talk about consent and confidentiality. The first words of the CMR, this is for the mission of the CMR's protection of the confidentiality of school records. And it's consent and consent.
But you agree this is not a school record under the CMR, or is that your position?
No, this is a school record.
So you say it is a school record?
This is part of the juvenile school record, yes. There's no question about it. With the barcode, the reference to the database, the administrator administering the database. What database would that be, if not the school records? That's the database. Justice Duffley, I would like to address something that you said when Ms. Celia was arguing. Imagine the feelings of the parents of the juvenile and the other 7 upon learning that the registration materials that they sort of signed off on when they registered their child in the school turned out to be used in a criminal investigation.
Let me ask you this. Under your theory, if the police had gone to the school and say, we have strong reason to believe that one of your students is robbing other students, is that a concern to you? And if the school says, yes, that's a concern to us, and the police says, we can't do anything unless you ask us to identify, that would be okay. The police would say, okay, police, I understand, and we as a school have a concern, and we, the school, ask you to do this. That's fine.
We as a school, in other words, sort of impelling the school to say, yes, please do this.
Not compelling, basically saying, does it concern you, Mr. Principal, that you may have a student who's terrorizing other students? And the principal says yes, but police, according to you, says, I can't do anything about it. I can't find out who the kid is unless you basically say it's your problem and you ask me to use your photos. That's basically the rule you're proposing.
I don't think he's proposing prevarication. I don't.
Your Honor, that's not the rule I'm proposing, because we have a name here. We have.
But if the school had said, if you had presented this to the principal and the school had said, golly, I've got obligations with regard to the bullying of students. I need to know whether this is the case. Please do it. You would say that's okay.
Your Honor, bullying is a big problem, and it should be addressed, and it's good that our society is addressing it, but that does not nullify constitutional protections for our citizens. The police.
That's circular, but
the police
the issue is whether there is a constitutional.
Let me ask you,
right.
Your Honor, could the police here, given the leisure of weeks passing, there was no emergency or anything like that, it wasn't on the school property, there was no imminent particular danger, could the police have gone and gotten a warrant here based on probable cause?
To say we're going to search the school?
No. To seek out the school, the photo.
But and this is, I've never heard of a warrant saying a warrant to make a request. I've never heard of a warrant to make a request.
A warrant to procure a document that's in a file in an enumerated place.
That's usually a subpoena.
Or a subpoena.
Subpoena doesn't require probable cause.
Why don't we leave it there? Thank you.
Thank you.